Hey everyone, Dan McKenzie here with the McKenzie Law Firm. Wanted to touch on a topic in this video that comes up in all of our estate planning conversations, and that is how do you leave stuff to your kids? Should it just be a pile of money that they plop in their bank account and off they go, or should there be some sort of restriction placed on it? And if there should be some sort of restriction, what is it? Who enforces it? When does it end? All those kinds of things always come up. It's an important part of your planning decisions. And so I thought I'd kind of walk you through our process for how we counsel clients on this. It's an issue. Obviously, there are some estates where not a lot of thought is needed because you have a small child, and so you have to put some protections in place for that kid. You cannot give that child money outright. You have to have another adult manage that for them. And then you might have family members with special needs who are not, the nature of their disability is just that they cannot manage funds, and so again, you got to give that money to someone else to manage for them. And so, but there are harder calls. There are children out there who are 20, right? And so they're on the brink of adulthood, and legally speaking, the day they turn 21, they really have all rights and responsibilities of being an adult. So if you give that person money, they have the right to do whatever they want with it if it's just a check to them in their name. And they might not be ready for that. A lot of inheritances actually are frittered away on kind of silly things, even when they're given to people who are much further along in life, much more used to rationing their spending and keeping tabs on things and working for their money and all that kind of stuff, more so than a 20-year-old would be, and you would think would be better equipped to handle those things, and not necessarily. So there can be reasons to put restrictions on a person at that point in life, but even much later, there are times where it makes sense actually to give people money in a way that is restricted, and not necessarily because you're concerned about them, but because you're concerned about creditors coming after them, divorces, medical bills, like all the things that any of us can encounter at any time where suddenly we have a financial distress in our lives that we hadn't had before. And so actually putting restrictions on money for somebody can protect them not only from their own bad decisions, but also from other people who might mean them harm. So the way I describe this to my clients when I'm trying to walk them through things is they really have a range of possibilities for how they're going to leave money to beneficiaries. And at one end of the extreme is to just say, go ahead and give it to them outright. Once we are done with the estate administration process, once you have figured out, trustee or personal representative, how much money do we have, we've paid the taxes, we've paid all the creditors, we've closed the accounts, we've canceled all the subscriptions, we've done all that stuff that we need to do to close out and kind of wrap up this person's life. And now we've got our money, we know who's going to get it, and how do we give it to them? And so once you reach that point, outright distribution, write them a check, put their name on the titles, off they go to do whatever they please. If they want to spend it on a really fancy vacation, probably not the smartest idea, but they can do that if they want to. Maybe they'll invest in a business, or maybe they'll invest in a retirement account or something like that. That might be a little bit more productive, but at any rate, it's up to them. I'm not going to try and control that in any way. At the other end of the extreme, you could say, once you reach that point where we're ready to make distributions, I am going to give money to these kids in these percentages, but we're going to keep that money under the supervision and control of a third party. And if my kids want to get their money, they have to go to that third party and explain themselves and say, here's why I want this money, and here, yes or no, can I have it? And that person can say no, obviously. So that's kind of why they're there. So if the kid says, hey, we want to take a trip to Disney World this year, how about some money for that? The trustee really could say no. That doesn't sound like a good use of this money. And so a lot of people, especially people with kids who have reached adulthood, feel like that is very restrictive. I don't necessarily want to control my kid's life to that level. And a couple thoughts there. I mean, one, I already mentioned that people often struggle a little bit more with receiving an inheritance than you might anticipate. But number two, as I alluded to earlier, actually, the more obstacles or barriers you put between the money and your kids also puts obstacles and barriers between your money and your kids' creditors. And again, they might come up, they might experience financial distress for a lot of reasons besides just making stupid decisions. And that might mean because they got sued. It might be because their spouse has decided to divorce. It might mean they've developed some sort of expensive medical problem. It might mean there's a pandemic. I am filming this in the middle of the COVID-19 thing, and the economy is closed down, and there are a lot of people who made all the right decisions, were living very, comfortably financially, and suddenly are in great distress through no fault of their own. And so having that money out there and having it be off limits to your creditors might be a huge blessing. And so I actually, when I revised my own parents' plan, actually said that my money that would be coming to me through this process actually would come through a trust, and I would not have unfettered access to it because I think it would actually be a good idea to have a pile of money out there that would be protected from anyone who I might cross paths with. There are middle grounds to this. This is a line and not just 2 points for a reason. You can say, look, I'm going to put this money in trust, but kid, you can be a co-trustee with the person that I've selected to be the trustee. So you're going to have some say in this. You're going to kind of see all what's going on, and you're going to have a vote. But at the end of the day, you still need to get this other person to sign off on it. So it's not, certainly not complete control. And they still, like I say, they still got to convince someone else that whatever idea they have is good. The next tick down the line is maybe to say, look, we're going to keep this in trust for you, kid, but you can be your own trustee. So you're the one making the decision. So if you want to go to Disney World, is the trust fund for this purpose? And you might think that yes, it is. And there's really no one there to stop you, whether that was what I intended or not. Why would you do this? Because having the money in trust at least gives them the argument that, hey, this money's in trust, it's not there to pay my creditors. So sorry, I know you just got a judgment against me, but you can come after my personal assets, but not, that money's in trust. If it really got tested, if your kid really was in front of a judge who was being asked to bust that trust and use that to pay money that your child has been found to have injured, being their own trustee is probably not the greatest optic in the world. It probably would, a judge would probably be not real sympathetic to that idea. So, and then, there's other things you can do. You can actually mix and match these positions. You can put different people in charge of different components. You can have a third party in charge, and you can tell that person, look, be liberal with it. Go ahead and give them the money. The default answer is probably yes, unless you really do see something distressing going on. If you kind of do a little of an investigation and find out like they are about to get divorced, or they are involved in a lawsuit or something like that, go ahead and hold on to the money. Then the answer is no. But otherwise, if everything seems to be okay, the kid seems to be working and living generally a life that seems reasonable, then go ahead and give them a Disney vacation. That's fine. So you can provide all kinds of instructions, and that money is still protected, but also available to the child. So this is kind of our favorite conversation to have with clients, and just kind of give them the lay of the land and give them options they may not realize they had. We get a lot of people who come in with kids who, like I say, have some challenges, and they might think that the only thing that they can that the only thing they can do is leave the kid money outright, or cut that kid out entirely. And those are not the only two options. There's a lot of stuff in between. So if we can counsel you on that, if you live in Colorado and are putting together your estate plan, we'd love to have that conversation with you. So we will put our contact information on this video, and would be happy to schedule an appointment. But hopefully this helps, and please watch our other videos and see what else we might be able to provide you, what other information we can provide you with. And thank you.